Good afternoon. We welcome you to Better Off Alone, the ins and the outs of solo appellate practice, presented by the Florida Bar. We hope you enjoy the program. We thank you for joining us today. At this time, it is my pleasure to turn the program over to your moderator. Courtney, please begin.
Thank you, Jared, and good afternoon, everyone. As Vice Chair of the Appellate Practice Section CLE Committee, and along with the committee's chair, Elaine Walter, I am so pleased to welcome you all to the inaugural episode of our Practice Management series. Before we get started, let me offer a special thanks to our global sponsor, Court Surety Bond Agency, for its support of the section and its programs. Many of you are likely familiar with our monthly webinars, which tackle various substantive topics or issues currently percolating in the appellate courts or rules committees. But the Practice Management series is designed to address, in a somewhat similar format, the practical aspects of being an appellate attorney. Our first episode of the Practice Management series is Better Off Alone, the ins and outs of solo appellate practice. As appellate practice has grown as a specialty, the boutique appellate practice has similarly taken off. But what is it like to venture out on your own in a practice area that's so dependent on relationships with other attorneys? Where do you begin? How do you keep it going? And why would you even want to? Our program today is designed to answer all those questions, as well as provide helpful advice generally applicable to all manners of solo and appellate practices. We are fortunate to have answering all my questions three panelists who are not only highly accomplished appellate attorneys, but who at various points in their careers took the plunge and ventured out on their own. I'm going to provide a very brief introduction for each of them and then ask them all to provide you a bit more details to explain how they came into their solo appellate practice. Jessie Harrell, who on my screen at least is above me, is a board certified appellate specialist and solo practitioner at the Harrell Law Firm in Jacksonville. She handles civil appeals in the state and federal courts with a focus on plaintiff's actions, commercial litigation, and family law. Ben Kuehne is the founder of the firm now known as Kuehne Davis Law, PA, in Miami. He specializes in criminal defense, white-collar crime, appellate practice, civil litigation, and election law. He is triple certified by the Florida Bar in appellate practice, criminal appellate law, and criminal trial law. And then David Sales is the founder and managing partner of David J. Sales, PA, an appellate law firm with a practice throughout the state of Florida. David is one of only 5 Florida lawyers certified as a specialist in both appellate practice and civil trial law. Attendees, as we said, if you have any questions, please post them and I will try to weave them into our discussion, time and substance permitting. With that, good afternoon to our distinguished presenters. David, why don't you start off and tell us how you got into the solo practice biz?
I'm flattered that anyone would ask me about management of a law firm, which is a business, because I'm the least likely person to be sought after for advice on that. I went to law school in Chicago at the University of Chicago. I worked for a federal judge, Judge Tom Clark, who's deceased in the 11th Circuit, and I went to work at a large, I'm from West Palm Beach. I went to work at a large firm in Boston. During summers in law school, I had worked only at big law firms, some of which don't even exist anymore. After I got out of my clerkship and worked in Boston, I was sort of bored being the third chair at depositions and things like that. And I returned to Florida. My late father, I'd always thought I might go to work for him. He was sort of the preeminent divorce lawyer in West Palm Beach. And God rest his soul, he wisely told me I shouldn't be a divorce lawyer. No offense to anybody on the call. And I ended up working for Jack Scroll at the Searcy Denny firm. I was there for 21 years, was in the management committee there, and found myself recently divorced and a full-time father every other week. I won't say that the appellate practice is easier or requires less hours, but it is easier to set your hours. I had a lot of nice relationships there and decided, had been doing mostly trials, very few appeals actually, and decided to do more appeals, and went out with very little casework, some hope for leverage with some relationships, and here it is. It's going to be 10 years. I guess it's hard to believe. April, May, June next year, it'll be 10 years. So that's what I do. I have one associate now, but I think that comes later. I'm supposed to talk about
We'll
that.
talk a little bit about growing your practice, especially when you're not such a great law firm manager in
No,
a few
that's
minutes.
not. Is that about what you were looking for in terms of an
Yes,
introduction?
that's great. Thank you. Jessie, why don't you tell us a little bit more about your background and how you came to solo practice?
I'm a double dater, and after law school, I went straight to work for Foley and Lardner, and I did commercial litigation for 7 years. But I did some appellate practice in there and realized that I really liked it, but there wasn't enough space at a big firm like that for me to really grow my practice in appellate. So I left and went with the Appellate Boutique of Creed & Gowdy in Jacksonville and was with them for 10 years. And then it'll be 3 years in January that I came out on my own. And this home office is not just my quarantine home office. It's been where I've set up shop since I came out. And it really, similar to what David was saying, I have two, well, they're teenagers now, 14, 15-year-old girls. And it's really about me being able to manage my time as a mom. Being at all the basketball games and horseback riding lessons and things that I wanted to do without the guilt of I'm letting somebody else down at the office, and I can really manage my own schedule best by being on my own.
Great. And then Ben.
My route to my current practice began as a government lawyer for both the state and federal system doing trial and appellate work. I then joined a relatively medium-sized, back then, 10-lawyer firm in Miami after leaving government service, doing trial and appellate work, and enjoyed appellate work. And a couple points in this career trajectory, being involved in the Florida bar was very helpful for my path. I did a lot of appellate work. I was a founding member of the appellate practice section and one of the founders of appellate certification, very important as part of the path, and felt that appellate work, helping lawyers be good lawyers, was really important and an area that had not been refined until we developed the appellate practice section. Then through a series of developments of my firm, I became a solo practitioner and now have a 4-lawyer firm, Kuehne Davis Law, of which my law partner, Michael Davis, is also board certified in appellate practice. So it's been a trajectory that was planned, but very helpful, setting little gemstones along the way.
All right, great. Thank you all. So Jessie, we're going to start with you, and our first broad topic is questions about before you went out on your own. So you talked a little bit about what motivated you to go solo. Do you have anything else to add to what you already stated? And if not, tell us a little bit about how you prepared for the process.
There's not really a whole lot to add about the motivation. As far as preparation, the few things I did, and one was talk to anybody who was willing to talk to me and just collect as much advice as I could. So I found that other lawyers who started their own firms, they had to go through the same process and they didn't do it on their own and with no advice. And so most people are really willing to talk to you and you know, you take them out to lunch and they give you an hour or two of free advice, and it's really sort of invaluable. The things I wanted to know most of all were about overhead, wanted to know the best practice management software to have, using accountants. I made some notes about things that I wanted. I think I said overhead, and just sort of figure out how I was going to run this business starting from scratch. And then I also spent some time building a website, which took a bit of research. I mean, I did hire someone to build it, but I wanted to make sure that the image I was putting out there conveyed that even though I was a firm of one, I'm still going to be very reputable. And so I knew that was going to be a big investment, and that was probably where most of my startup money went, was into designing a logo and a website that would really be top notch, because I didn't want people to go on there and think, or she just went on her own and threw a website together. You know, I wanted the people that I had worked with, because as a lawyer, as an appellate lawyer, most of your clients are lawyers. But when they're telling their clients, this is who we're going to hire, I wanted the clients to feel comfortable that this was a good person to bring on board. Let's see. Oh, and one of the things I decided too, you have to think about whether you want to have SEO optimization. And this was not something I had ever really given much thought to beforehand. The web designers really want to push the SEO optimization, get your firm to the top of the search browser when someone Googles appellate lawyer Jacksonville. And I decided that I didn't want that. I wanted to focus on the relationships that I already had. And I didn't, because I don't have a staff, I didn't want to be fielding calls from every person who plugged in appellate lawyer Jacksonville, Florida, and decided they would give me a call. Because I don't have any staff and I knew it was going to be me answering the phone. And so that's something I thought was important to share with folks that are considering this, that you might not want to bump your website to the top of the list if your business model is not to have staff. Is that a fair answer to?
Yeah, no, I'm glad you explained what SEO optimization was, because I wasn't on the same page there, but makes sense. That makes a lot of sense. So would you say that the hardest part of the process was figuring out all this technology and kind of the business side of it, or something else come to mind?
I mean, certainly the fear of the unknown was probably emotionally the hardest part, because if you've never done it before, you don't know what to expect. But definitely learning how to wear so many different hats was difficult. I tell people that the first thing I filed, and I think it was a notice of appearance, took me about half a day, which I was used to taking about 5 minutes, but all the login information had changed at the various courts because I was now on my own and had a different email address. And so the initial ramp up of getting yourself going and making sure you have your logins for every court, and I mean, now it's different. You don't have the, you still have EDCA, but you can file everything in one central place. But learning how to format my briefs and do everything on my own was a challenge. But it smooths out. It only takes a couple months at most, I think, for me to really have a rhythm of, okay, my accountants are going to come in and they're going to do X, Y, and Z. I'm going to review it and I'm going to get my bills out, and just putting yourself on a schedule and getting it all done.
What about you, David and Ben? Any other thoughts about what the hardest part of the process of going solo was?
I had a little bit of a different trajectory. I made the decision to leave. I had one client who wanted me to do their appeal. I had done very few appeals where, if you look for me in a case prior to 2010, you wouldn't find very many appellate cases. I went and got a $900 office space in what was considered to be a good building, not far from my house, since I needed to take care of kids. I bought 2 computers at Walmart, and the best thing that I did was persuade my then 70-year-old secretary who had worked for me for 20 years to come out of retirement. And she got all the administrative orders from all the DCAs and the 11th Circuit rules. She read them all and made sure I didn't screw anything up. One of the things that makes it a little bit easier is the EDCA. The other smartest thing that I did was become very good friends with John Mills. And not by design, we had worked on some stuff together. And he was very generous, as were you, in the early days, looking at some of my papers, hopefully not thinking that my arguments were lousy, but making sure that they looked, like they belong to be filed in an appellate court. But the electronic filing makes it so easy. I do have an office now also, but you don't need anything. I don't have a trust account. I have one staff person. I have an accountant like that, but it's very easy. I thought it was important to get a website too, and I got one. I've never tinkered with it at all since I use it for me, because most of my work comes from or indirectly from my former colleagues, and now others around the state. I don't think I've ever gotten a case off the website, but I think that would be obviously important to have one that looks like your real grown-up lawyer.
All right, Ben, anything to add?
A person opens up a business either because they're forced to or they want to. And either way has opportunities and some problems. But what is the most attractive about an appellate practice today is that your business comes from two sources. It used to be, as pointed out, that only lawyers referred matters to appellate lawyers, so that lawyer relationship networking was critical. It's still very important. But today, appellate lawyers get cases from clients because of a web presence, as Jessie pointed out, or because of work you've done that people hear about cases and outcomes. And that is both surprising and invigorating to get a call from somebody who says, I want to hire an appellate lawyer, and it's not another lawyer. So that gives lawyers who want to do this much more of an opportunity to expand your business and create your craft. I heartily encourage working in both areas.
Can I say one other thing?
Yeah.
You know, I wasn't board certified in appeals. I hadn't done very many, but I will say this for those of you who aren't and who are considering going out on your own. I did, and fall on what Ben was saying. I was relatively quickly in some situations where I was being interviewed for work that I didn't get, and didn't get it. And one of the reasons it was given to me on one occasion was that I wasn't certified. I don't think my briefs are better or my arguments are better, but I do respect board certification. It's an important credential, and if you want to get hired from routes other than through existing relationships, or even with existing relationships, it makes it a lot easier for a colleague or a former colleague to pitch you as a prospective appellate lawyer if they've been the trial lawyer, if you have a credential. So I think it's important to be working toward that now.
Yeah. No, I mean, it's one of those things that when someone asks me to help them find a lawyer and I just don't have familiarity with it, I check with my friends in that area, but board certification is the next list I look at. So Jessie, back to before going out on your own, did you have a backup plan? What if it all blew up in your face and you didn't get a single call, or was it sink or swim?
It was sink or swim. You know, I have the luxury of being married to another attorney, and we were able to, because I do both contingency and hourly work, I'm not going to say it didn't matter if I didn't make any money in the first year. I certainly wanted to continue earning an income, but I had to plan that I was going to float a lot of this because the contingency cases weren't going to pay off in the first year. I mean, you just know that the appeal is going to take longer than that. But the hourly work I found was very helpful in filling the gaps. And I actually enjoy the trial support and hourly work as much as the appellate work, which sort of surprised me, that because I had left the trial world to get back in, you know, to really focus only on the appellate world. But I really like having the mix now, because I don't have to do the things I didn't like about trial work, which were depositions and discovery and those sorts of things. But you still get a little bit of the fun of being in the courtroom and arguing some real substantive motions, which didn't really answer the question. But just to be more a little bit open-minded about what sort of projects you're going to take on, and you know, you can get through the startup period.
Oh, yeah, that's all good things to think about. So do you have an opinion now on, for those who are listening and maybe thinking, gosh, this sounds like a ton of fun, they're making it sound so great. What sort of personality traits and work styles do you think are most well suited for being able to go out on your own?
I think is the introverts unite sort of thing. I mean, maybe that's just me, but I work in my house by myself with my dog who is behind me. You have to be okay to not have anyone to talk to for several hours at a time. And that is one of the things that I do miss the most about being in a practice, is having other people to bounce ideas off of. I really enjoy just sitting down and talking through things, because sometimes that helps you get ideas into focus. So you really have to be able to do that internally. I certainly, with our appellate practice, I wouldn't recommend it to someone who doesn't have a decent amount of experience as a lawyer in some field. Whether, you know, David was saying he didn't have a ton of appellate practice when he went out, but he certainly had a great, vast knowledge of trial work. So I mean, to not have a base to start from, I think would be very difficult to jump into the appellate field. But if you don't mind being a bit introverted and you have the discipline, for me, one of the things I had to really make myself do was not treat my home job different than I would if I had been in an office. So there's no doing dishes or laundry or watching TV, anything during the day, just because I'm home. If I wouldn't have done it at the office, I won't do it at home, at least at first. So having that self-discipline, I think is important if you're going to really, because nobody's looking over your shoulder.
I bet. David and Ben, before we move on to kind of the how, when you go solo, anything to add to whether you all had a backup plan or thoughts about what makes for a good solo practitioner?
Ben, you go.
I first want to emphasize that one of the most critical aspects of starting your own business, and that's what a sole practitioner is your dependence on income for a living. Don't be surprised, because you will do great when you make that decision, and rarely does somebody second guess that decision. But you best be prepared for the hard times, and they will come no matter what your success is. If you're dependent on an income to pay your college loans, to pay your mortgage, and that income has to come in every month, stop, run away from a solo practice, because you will be desperate for a time. And that's my strongest caution. A sense of confidence that you will succeed is important, but having the ability to earn a living, pay your bills as you work through, is equally important.
Yeah, just, I mean, and it doesn't necessarily end the first year or second year. I was very lucky in the beginning. I got some good hourly work that was very helpful. But you know, well, some of us do contingent fee work, and you can work your tail off running out your supply of work that you've got right now. But the fact of the matter is that the coronavirus, you know, if you do contingent work at appellate work, there have to be results. And there's going to be a trough next year for those of us who are at least in part dependent on that. And then, you know, a lot of trial support work in 2021 in the second as well. So, but I agree with Ben. If you are not able to sustain a period of time of being broke, relatively speaking, you have to be careful about that. I do think, I will say one, I do think you can be an appellate lawyer for very little money. You know, you need a malpractice policy. They're not, for appellate work, even if you do plaintiff's work, they're not super expensive. You need an office space if you can't work at home. I couldn't, because it wouldn't work out. You need a couple computers and an internet connection. And you know, if you have work and you have those three things, malpractice, you know, internet connection, and a computer, you can make money, and you can make money relatively quickly.
All right. Excellent. All right. Well, so I think relationships have come up a couple of times. It's kind of sounding like a bit of a theme as you got started. And so moving into this, actually going solo, and Ben, I'll ask you to take the lead on these questions. Where do you begin to get your clients? Where did you begin, and how do you let people know, hey, I'm here, send me your work?
The time-worn path, as a famous writer talked about, is not necessarily the way to go, but it certainly is the way everybody went. And there is no doubt that today, for practitioners today, having a fully formed network in the lawyer profession is critical for getting and sustaining an appellate practice and developing your own individual ways to get appeals cases. And I strongly encourage, and this is a bar-related matter, of course, getting involved in your bar association so lawyers know you're a good lawyer. And then making yourself indispensable to your colleagues. And much has been said about litigation support. Let me strongly encourage every appellate lawyer or appellate lawyer to convince your friends who are trial lawyers that you can add value to their case, even if it's a loss leader, even if you're going to do it for almost no money because they're handling a contingency case. Once you prove to that trial lawyer that you can help develop deposition questions, that you can work up a summary judgment, that you are spot on with jury instructions, that lawyer will see you when the lawyer wins that trial and wants to defend that case on appeal. Or in the few times that your lawyer doesn't win the case, the flip side, to get you to win the case on appeal. And that word will spread. And the best part about it is, you mentioned this, your cost overhead is low, that you won't end up costing the trial lawyer a lot of money for adding extensive value. That's where you should spend your time. And if you have to work nights and weekends, look, I work nights and weekends. Everybody I know works nights and weekends because we love what we do and we do the work we have to do. But as long as you're willing to work nights and weekends, you can get all those other things done, even if you're not getting the paycheck for it today. It's either going to be a paycheck on a contingency later on, or it's going to be a great reward planting that seed and having the appellate tree grow.
So we have a question kind of on point from the audience, and whether you could estimate for us what percentage of time do you think you spend on legal work versus administrative, administering your law firm, managing your law firm, versus business generation?
How many children do you have and how old are they? Is the answer that I have. As one of my former partners says, you are only as happy as your least happy child. So it's not very much. I mean, it depends how you run your life. If you use your staff as a lot of, so the smaller you are, the more likely it is that you need your staff to help you with your personal life. So I'm not the best person to answer. For me, it's really a function of what other demands are being placed. It does not take a lot of time. If you have a decent account, you have a Westlaw account, it does not take a lot of time to run an appellate practice. It doesn't.
Any other thoughts from Jessie or Ben on that question?
From an organizational point of view, depending on how you set up your practice, there are a couple rules of thumb that LOMAS, a Law Office Management Advisory Service, which is a free service with the bar, tells you. But one of the things lawyers, let's say managing partners, well, that's the solo practitioner, you've got to be careful if you're spending and tracking all of your time more than 15% of your hours on office administration. If you're doing that, you need to rethink how your office is being run. But trying to get below that is almost impossible for anybody who really cares about the rules governing keeping an office in compliance with business requirements, legal requirements, and professional requirements. So that's the rule of thumb.
Jessie, any other thoughts on that question?
I'm just going to say, for me, the most helpful thing in keeping the time I spend on the business side of things very low was getting good software. I use a program called CLE, and so I can keep all of my time and my expenses. It generates the bills. It integrates with the platforms that my accountants use to come in and do everything on the back end so that I don't have to touch it. Having a program that you're comfortable with and that integrates with everything you need will really cut down on the amount of time you have to spend running the business of the firm.
All right. So another question from our audience, but also one that I had wondered about as well, is Ben, when you're going out on your own, who's reading your briefs for you? Who's making sure that it's site checked properly, it's proofread, all those typos that we can never seem to catch when we're writing the brief and we've read it 10 million times and someone else magically comes in and finds, hey, you misspelled the here. Who did that for you before you had associates and partners?
This is where the concept of networking really comes in. Friends are going to help you. Two rules in that regard. One, and you've heard them both. One is the top drawer rule. Nothing goes out without putting in the top drawer. Now it's putting it in the folder on the computer and not looking at it for a period of time, whether it's half a day or preferably a day, and then picking it up with new eyes. That's one. Number two, nothing goes out that is more than a notice of appearance that took Jessie a half a day, and I remember those days to get done the first time. Nothing more than that goes out without another set of eyes looking at it, preferably a friend who's willing to take a quick look, or, and don't undersell this, a law student, law clerk is an inexpensive way to get a good set of eyes, and you feel great at the end of the day when you pay that modest amount of money to have a law student know that you're teaching that law student what the law student doesn't learn in law school. And reading and editing is great. If you get a law student who's on the review, even better, but it doesn't have to be.
Yes, law clerks are very instrumental. How about getting ready for an OA? I don't know how you all feel about moot courts. I haven't done an OA without at least talking a case through with somebody, either in my office or, to his dismay, my husband occasionally. What do you do when you're out on your own to get ready for an OA?
Who's that one for?
That was for Ben, but
let's have David take a stab first.
Okay.
I will say this. Because I did a lot of trial work, I was in court making arguments to judges. I still do a lot in trial courts. And I figured, hey, I've had 2-hour summary judgment hearings and whatnot. And I could, it doesn't take that long to prepare to talk for 15 minutes or 20 minutes. Of course, if you've got a 40,000-page record like we have for me a lot, it's a very different story. And I will say this, I prepare more today for an oral argument than I did 10 years ago. I work harder at it. I read more. I read more of the cases thoroughly than I did before. And for an oral argument in what I would call a complex case, and if they're getting an oral argument, most of them are, not all, it takes about a full week for me to get ready. I mean a 50-hour week. And then what I do is my associate and we have this sort of chaotic way. I write everything out. Whereas I used to get up there and stand and speak and felt like I sounded good. I do it like I did when I started, like my father told me. My father used to say, write down every question you're going to ask. And I used to do it too. I used to write down, what is your name, when I took a deposition. And I do that now. I write down, may it please the court, and I do it at a computer. And after I've read and reread, and this is no BS, read and reread the briefs over and over again, and tabbed all of the record and the depositions and the law, everything, and I've gone through that 2 or 3 times. I close everything and I sit down at my computer and I write it out as though I was going to be making what a friend of mine calls the argument I hope to be able to make, get to make. And then, which I just started doing in the last year, I have my associate do the same thing. And we take those 2 sets of notes, and whoever's is best, you know, usually mine survive, more of mine survives than what he writes for me. But that's what we do. And my main message is it's hard work. I work at it much harder than I ever thought I would have to get ready for OA. That's how I do it.
I often compare an OA to a law school final because you have to know the record and know the case law cold. And so I agree, it takes me at least a week to prepare, going back through all the briefs, the record, the case law. I make an outline of the points I want to hit. And then I also do a separate table of all the cases, because sometimes when you're up there and a judge says, well, what about case X versus Y, and you're on the spot, I like to have just a tiny snippet as to what I cited that case for, the other side cited the case for, to refresh my memory, so that I don't blank in the middle of OA. So, but usually by the time you go through the process of doing all that, and then because I don't have an associate, I talk to myself a lot. I go through and, you know, I speak the oral argument. I do it when I'm walking around the house. I do it in the shower. My husband has to listen to me. But by talking it through, you sort of work through the points, the questions you think you're going to get, the hard questions, how you're going to answer them. And after a week of just living that case, I feel I'm prepared enough to do an OA even without having had a moot.
All right.
The moot or not moot is the age-old question. They have seminars just about that. I'm not going to offer a view on what's right for you, but let me give you 3 things that will help you. 1, you need to have a system in place that you use on the big case and the small case. 2, the time you spend investing is inversely proportional to the time you spend expending. Only meaning, as David points out, 15 minutes doesn't mean you should spend less time than your 2-hour summary judgment argument. It means you better spend more time, because 2 hours of summary judgment, you can cover lots of chaff and get to the wheat at some point. 15 minutes, if you don't have those gemstones there, you might as well have waived oral argument. And the third item is that you should always have available somebody to hear you at least once, even if it's not a dialogue. Some would benefit from a dialogue, but at least hearing what you say as you say it out loud to somebody else is desirable. Those 3 rules will get you well, no matter what your style is.
Okay. Before we talk about taking on associates, first Ben and then Jessie and David jump in. Is there anything else about logistics you wanted to offer up? Office space, we talked a little bit about technology, bar service, anything along those lines that you guys wanted to share?
If you want to be known as a writer, write. Find a chance to write for the Florida Bar Journal. Find your Dade County Bar Association newsletter and write a little squib on some fun case you have. If you're really good at it, and it sounds like the panel is good at it, come up with a blog and be known as something, so you have a service where people think of you when they say, oh, quirky question, I'm going to ask David. That's thought-provoking. Let me call Jessie. That is as important as having your computer and networking. It'll get to a lot of eyes. So I strongly encourage you to weave that into your time. And by the way, as you're starting off, you may have more time to write some of these things for no purpose other than your own purpose. And hopefully you'll get to the stage that you'll have so much business that your law clerks and associates will be helping you write. And the teaser to them is, hey, you got a byline. Of course, your name comes first.
Fair enough. David or Jessie, anything to add to logistic stuff? Right. All right. Well, so on that law clerk associate thought, David and Ben, who both have associates, and Ben, who has a partner, how long after going solo did you take on an associate or hire other attorneys, and what motivated you to do so?
Mine's probably easier in the beginning, and this relates to what we were talking about before. I'm a terrible proofreader. I'm a good writer, but I'm a terrible proofreader, and I can't see my own mistakes. I had worked with a lawyer in Florida. I knew she always needed work. She was a solo practitioner, and I used to pay her $10 a page to proofread my work. She wasn't allowed to change the substance, and that seemed to work fine. I subsequently worked for a client who had an in-house lawyer who had been a real estate lawyer before that. And he asked me, he was a very smart guy, went to Harvard Law School. He asked me if I had work for him. And I kind of started giving him some things to write, some records to review. And then I got busier, and he became my full-time associate. But we had sort of a trial period, and it's worked out very nicely. So we keep the volume of cases that we have to be right at the level. I don't turn down a lot of work, but we try to keep things right at a level where just the two of us can manage that. And we have a sort of a system, brief writing and argument, trial support, where our responsibilities are very clearly divided. And I would say, don't take on a family that you need to feed until you can afford to feed another family. That's similar to Ben's earlier advice about if you can't afford to be broke for a short period of time, be careful. But I think you really need to have enough revenue, even if it means a short period of time having left yourself before you commit to taking on, supporting another family, which is the way that I look at it.
My rule of thumb is one of practicality. If you find that you are cramming to read your record twice and you have to cram to do it, you need somebody to help you, not to not read the record. And let me emphasize, any lawyer who has their name on a brief, who's personally responsible for that brief, better have read the record. Maybe you have somebody else summarize it for you and you read the record while you look at the summaries, but you better have read the record. Do not ever rely on somebody else to do that. But in terms of the workload, if you can't get through your record, and by that I mean all the materials you need to do a good brief twice, you need somebody to help you. Short of that, you can do it yourself as long as you have an affiliate to be the eyes to help you, which, by the way, could be a paralegal, could be preferably another lawyer or trained paraprofessional.
And Jessie, for you, do you have any plans to expand? I'm not, looking for jobs on behalf of our attendees or anything, but do you have any benchmarks in mind about, yeah, I might hire an associate if this, or not?
Things have just been so smooth for me with the work-life balance, and I haven't, so no, the short answer is no. Perhaps when they're out of high school and I'm not being as much mom as I am lawyer, then that might change. But to the points made before, I don't want to take on somebody and be responsible for their salary and the significant increase that would require my marketing to do that. I'm just really happy with the status quo right now.
That's
Except that, Jessie, after law school, for sure, there's going to be an opportunity to add an associate for your children.
We are not actively encouraging law school for them.
It almost seems like with 2 lawyer parents, it's a done deal, but I guess we'll see.
They don't think what we do is terribly interesting.
Okay, fair enough. So David, you said it's been a decade for you now. So looking back, if you were able to do it all again, anything you would have done differently in the first year, the first couple years of your solo practice?
I would have changed the composition of the judges on a couple of the first panels that I argued in front of to make sure that those early contingent fees that I had hoped for would have actually come in. I can't, no is the answer. I'll tell you, it's like any other small business person, and it's not for everybody, but I had a very nice career. I didn't leave because I was mad at anybody or wanted to do anything at my old firm. They've always treated me like a prince in many ways, and it was very rewarding financially and everything else. But when your overhead is not, contributing to supporting 130 families, and really just 2, my secretary and I, when we started, and you know that your overhead is a tiny fraction of what you used to have to generate in order to survive, particularly if you're careful on how you spend your money in the beginning. You get that first check, and it's like I'm sure it's like somebody who sells their first car or makes their first win. It's very, you get to keep all of it, and you get to treat your employees nicely when you do well. So it's very rewarding. So I wouldn't change anything. I really wouldn't. The only thing I would do differently is I would have done more appeals earlier and tried to have the board certification credential. I don't think it affected the trajectory of what I've done, but I think it certainly could for others, and probably would have eliminated some concerns that I had. Like I said, I remember very well one case I didn't get, probably a very lucrative case, because I wasn't board certified at the time. So that's the main thing that I would be, if you're thinking about it, and if you're a planner like Ben and you plot it all out over a number of years, one of the things you should be doing now is keeping track. And it's a lot easier if you're planning to get board certified to look at what the requirements are and be tracking, count your oral arguments, figure out which briefs you want to use. So those are the only things I can think of. But I would, in terms of the logistics of it, if you can be comfortable with with an Office Depot chair and a Formica desk until you can afford a good one, or you can work at home. If you don't need fancy to surround you, I wouldn't worry about it at all. I really wouldn't. It's so inexpensive. And if that Ben's in his office, it looks like he's got a pretty nice office. And now I do have a nice office, but nobody ever comes to see me. So you don't need, now I have some nice chairs and whatever. I have some things on the wall, and I own my office now. It's wonderful. But in the beginning, trial lawyers, if you're working for a trial lawyer, you go to the trial lawyer's office. They don't want to see what do they want to see? The record on appeal? Especially if you do plaintiff's work, they want you to come and see their swords on the wall and their lions and things like that. We don't have those things.
That's right. Ben, David referenced how you had everything all planned out, but now looking back, would you have done anything differently in that plan in your first year or two?
Without suggesting that I was not a person who could foretell the future, because I certainly like people to think that of me, let me share a couple kernels that will help you as I think retrospectively. 1, take a business class. Have some business experience. Go to the community college, not business law. Learn about books and accounting. That will help you avoid the stress of end of the year requirements, of having to solely rely on a vendor and not have any idea what that vendor's doing. So that's one, very important. And frankly, I think if you're adding associates, make sure that your associate has some sense of business, because one of the training grounds is teaching the associate about the business, not just the law part, but the business part. Second, use every chance you can to volunteer to participate in writing an amicus brief. You get no money for it. They're fun issues. Follow cases, invite yourself into an amicus brief. Obviously, professional networking is important, but find the issues that need other views and write. That will get you writing experience where you don't have, without any disrespect to Jessie's dog, a dog in that fight. And just write for the pure love of writing and persuading from a neutral perspective. And the third aspect that I think is really important as you look at this path is, have you done the kind of things that your personality helps you like doing what you're doing? I respect that Jessie says her children don't think what she does is that interesting. I think that's a mom speaking and not what the children are saying, because I can assure you, my children, but more especially my grandchildren, think what grandpa does is the most fun work in the world. And it's all about your attitude, what you talk about. So, sir, are you doing the things in your life, personal and professional, that complement you so that you leave your workday, whether it's your virtual workspace or not, say, you know, I did something good today. And that work-life balance is called now, needs to be added into your professional mix the day you start being a lawyer, if not before.
Jessie, anything you would have done differently in your first year?
That's just such a hard question. I mean, there were some things that I was really glad I did, like I got my former secretary, knowing I wasn't going to have staff, I got her to come to my house and I paid her to teach me how to format briefs and you know, do a lot of that secretarial stuff. But I think I might have done even more of that, so that I wouldn't have spent half a day doing a notice of appearance or you know, a little more prep work on the front end as to being self-sufficient and wearing the secretarial hat would have saved me some time and some headache. But I think that's just for me, it was really doing, you know, I was glad that I took the time to research different platforms and figure out the right document management system, and not necessarily try to cut corners, because some of the solo practitioners that I talked to, they wanted to keep their overhead as low as possible. And so they were, you know, managing files through one platform, and, you know, they had multiple different things going on. And the platform I found I didn't think was terribly expensive and well worth $100 a month to make everything streamlined. And so I was glad that I didn't fall into the trap of trying to keep my overhead super, super low or artificially low at the expense of the time that it was going to take me to run the business. Because I know that when you go out, it's scary to have the overhead. I mean, the insurance isn't that much, but it's a big, you know, when you're starting with not very much, it's a big chunk right off the top, and you're trying to think about every way that you can keep your expenses down, because you don't know how much hourly work you're going to have, or when the contingency fee is going to come in, or you know, in the family law cases, your clients often can't pay you all right up front, and they've got to do it over a payment plan. And so the money isn't always steady and consistent. And so I certainly appreciate the desire to keep the overhead as low as possible, but just to not do that at the expense of your time, because that's what you can bill is far more valuable than what the overhead, you know, what you would spend a little bit extra in overhead.
All right. So we are getting close to our time, so I want to ask one more question, kind of reflecting that hopefully captures all the other questions we were going to ask in this looking back section. And so David, what has surprised you the most? What's kind of your big takeaway you'd like us all to, I guess that's really two questions. Let's start with what has surprised you the most about going out on your own.
I did not like being solitary. I liked the social part of my practice before, and I do miss that. But I think the thing that surprised me the most is that I've sort of forgotten about, not forgotten about it and that I don't remember it, but that it seems less important to me today. And it does make you realize how much time you spend in non-productive activities when you work in an office with a lot of people. Having said that, particularly now with the way that we live, that it is much easier. The reason I don't miss it as much is because I have 3 or 4 people that I do almost every day. John sometimes is one of them, and a couple of other lawyers that I work with, collaborate with frequently. I'm on the phone with them every day. So that those electronic relationships can satisfactorily, at least to some extent, replace the in-person relationships, I think is the thing. I know it's not sort of maybe a surprising answer, but that's the thing that surprised me the most, that I certainly don't miss any commute time, but that I don't miss the being identified with the big firm and a prominent firm as much as I thought I would. And it's partly because of the satisfaction that you get from being your own boss. Very satisfying.
Yeah. Ben and Jessie, any last thoughts? What surprised you the most? Anything you want the attendees to take away from today?
In a surprising but incredibly rewarding way. The first is you'll look back and say, wow, this was easier than I thought, and it will be. Number 2, the amount of people who rely on you when you're known as an appellate lawyer, the calls you get from colleagues who are not tight with you. Hey, I just had this happen. What do you think? And that's incredibly confidence building. They're calling me. And the third, which we all learned in law school and forgot in the early days of lawyering, is how easy it is to learn new things, learn new topics, learn new legal areas. Because when you have your small appellate practice, you're not guided by, I'm doing another slip and fall for the 17th time in a row. You're getting this wide range of things, some of which you were saying, they hired me to do this issue? I never did this before. And soon enough, you'll tell everybody you're an expert on that issue. And that is incredibly rewarding.
All right, Jessie?
One thing that surprised me, and I guess I had never really given it much thought before I went out on my own, was, and I don't want this to sound bad, but I can make the same amount working for myself in fewer hours than I could working for somebody else. And I always thought that I was paid well, and I guess I'd never, I didn't break it down. I was happy doing what I was doing. I loved the people I worked with, but when I sat down to sort of make a business plan when I started out, and my software does this for me, actually says, how much do you want to make? And it told me to do that, I needed to work an hour and a half a day. I was really surprised that I could accomplish what I was looking to do in not nearly as much time. And so I generally think I work more than an hour and a half a day. But, I was surprised that when your overhead is so much lower by not having an office building and multiple attorneys and multiple staff and all of that, that there really is a lot more at the end of the day, and it frees up your time for you to manage it how you want to and run the business how you want to. So I didn't ever really think about the financial benefits too much beforehand. I just knew personally it was what I needed to do. But I was pleasantly surprised by what you can accomplish being on your own, even at a very reasonable hourly rate.
Well, thank you all. I thoroughly enjoyed this discussion and just want to thank all three of you for being here today on behalf of the CLE committee, the section, and the Florida Bar. Many thanks again to Court Surety Bond Agency for its support of the section and its programs. Thank you to all the attendees for joining us today. Our practice management series, I think this was a fabulous first episode. We will continue on January 7th with another 2021, of course, with another video webinar when Robin Bresky will present on ethically marketing your practice. And our monthly webinar series returns on January 19th for the Appellate Law Year in Review, looking back on 2020 with Matt Canigliaro. For details and to register for these CLEs, please check out the section's website. And finally, the course number for today's seminar is 4628. Again, that is 4628. Thank you everyone for joining us and have a great day.
Thank you all.
Bye.